Good afternoon. We are going to go ahead and get started on our program for this afternoon. Thank you for joining us so much for this presentation today. Constitutional Rights, Balancing History, Liberty, and the Common Good. Today's presentation is being enjoyed not just by those of us who are present here in the Lincoln Auditorium of the Capitol Building, but also in classrooms and in educational institutions across Idaho. And that's my reminder to those of you who are in the audience that this is being broadcast on Idaho Public Television. So don't do anything embarrassing in case the camera pans over to you. And that's a reminder for myself just as much as it is for you, I promise. My name is Colby Reddish. I am an attorney that works in private practice here at Smith Malek in Boise, and I'm happy to welcome you on behalf of our partners to this event. I'll spare you my bio because I am the least important person you will hear from today. I promise that. Let me introduce our partners for today's event. The first is Attorneys for Civic Education. Attorneys for Civic Education is a volunteer product sponsored by the Government and Public Sector Lawyers section of the Idaho State Bar. ACE's vision is to increase and sustain the opportunities for civics education in Idaho schools in order to ensure that Idaho citizens have a solid understanding of the Constitution, the rule of law, and our form of government. Through volunteer outreach and education, ACE is committed to supplementing a quality civics education for Idaho's young people. In addition to today's programs and some of our other projects, Attorneys for Civic Education directly supports 4 civic education programs in Idaho: We the People, 4-H's Know Your Government program, the YMCA's Youth and Government program, and the Idaho Mock Trial program. ACE meets the second Thursday of each month and is always looking for new members that are interested in furthering civics education through our state. And it's not just for attorneys, as Russ Heller can share. He's a member of our group that's a retired teacher, right? Our second sponsor for today's program is the Idaho Law Foundation's Law-Related Education program. The Idaho Law Foundation is the charitable arm of the Idaho State Bar. As a program of the Foundation Law-Related Education, the Law-Related Education is a statewide civics education program that works to enhance public understanding of the legal system and bring together attorneys and teachers to help students of all ages understand the role of law in a democratic society. The Law-Related Education Director, Carrie Shuffler, deserves a big thank for her work in putting on today's program. So let's talk about, perfect. That's what happens when I forget to write hold for applause in my script. So why are we here today? It's to celebrate Constitution Day. So Constitution Day is September 17th, and it is to remember that the U.S. Constitution was signed on September 17th, 1787. And by federal law, each educational institution receiving federal funds is required to hold an educational program remembering the day. I want to thank each of you for taking the time out of a Friday to join us in celebrating Constitution Day. That helps us remember this. This is now the 3rd annual event on this day from the Lincoln Auditorium. And one caveat I have to get out of the way is that while we would love to take questions from the audience or participants, in the past, time has not allowed it. And so we're not planning on taking audience questions, but I will tell you that the Attorneys for Civic Education website has a good contact form that if you do have questions, feel free to send them there. As a brief roadmap for our presentation today, we will start with a keynote from Chief Judge of the Idaho Court of Appeals, Jessica Lorello, and then we will turn to a panel to help discuss the topic at hand. So, by way of introduction, those who know Chief Judge Lorello know that one of her great passions is to further civics education here in Idaho. In fact, we were just talking about the fact that I'm only involved in this institution because she dragged me along as a law student 8 or 9 years ago and has never let me leave since. Now, last night I asked Chief Judge Lorello if she wanted me to read a brief bio to introduce her to those of you who don't know her, and she replied with a no and a smiley face emoji, which I think is probably introduction enough, but under the risk that I may receive a contempt order later today from the Court of Appeals, I will let you know that Judge Lorello is a 5th-generation Idahoan, a Boise High graduate, and that after some time in private practice and government practice, Judge Lorello was appointed to the Idaho Court of Appeals in 2017. She is also a recurring adjunct at the University of Idaho's College of Law, which demonstrates her commitment to education at all levels. Judge Lorello.
Thank you, Colby. It was nice of you to say that I said no in response, because I actually said nah, and the smiley face. So good afternoon, everyone. Also on behalf of Attorneys for Civic Education, I want to thank you all for being here, both in person, and I believe we have a fairly good showing online as well. You may be here for the CLE credit, or because your teacher told you to, or because I encouraged you to, but the underlying reason we are all here and what we are celebrating today is Constitution Day, albeit a couple of days early. September 17th is designated as Constitution Day and Citizenship Day to commemorate the signing of the U.S. Constitution in Philadelphia on September 17th, 1787. So why do we celebrate Constitution Day? Because the Constitution was written for us. And it's important to understand how the Constitution is connected to each of our lives, both in the rights it affords to us as individuals, but also in the related responsibilities it requires of us. As we celebrate Constitution Day, I think it's worth taking a few moments to highlight its preamble, which reads, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Equally important is the preamble to the Bill of Rights, which reads, "The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution." The language of the Constitution, including the amendments thereto, do not stand alone. As our distinguished panel members will highlight today, the courts are tasked with animating those words and defining their scope. The question becomes, how do the courts do it? What principles are judges guided by in doing that work? How does a judge or a panel of judges, like the United States Supreme Court, the final arbiter of constitutional interpretation, determine what is meant by the Constitution and its amendments? For example, the 14th Amendment precludes a state from depriving any person of life, liberty, or property without due process of law. But what does that mean? Courts are tasked with answering that and related questions about the meaning of the Constitution. How the Constitution is interpreted impacts us all, perhaps in ways that are not always apparent, but impactful nonetheless. One interpretive method invokes the phrase ordered liberty. Applying this framework to the 14th Amendment's Due Process Clause requires an inquiry into whether a claimed right under that amendment is deeply rooted in the nation's history and implicit in the concept of ordered liberty. Even this framework leaves a lot of room to discern its meaning. But it is fair to note that judges aren't necessarily historians, and it's fair to question what history and whose history dictates or at least influences the results. It's also fair to ask what deeply rooted means, and even what ordered liberty truly means. And what about the fact that there wasn't even unanimity at the time of ratification? If it seems I have more questions than answers, that is a fair assessment. But what is important in my view is to ask the questions in order to better understand our Constitution. In that vein, I would encourage you to think about how or if changes since the Constitution was drafted should be part of the analysis. How, if at all, does the fact that women were not participants in the Constitutional Convention or even have the right to vote until 1920 factor into the analysis? Even more broadly, what about the fact that our society looks vastly different today than it did in the 1700s and 1800s? not only in its demographics, but in a myriad of ways as a result of advancements in technology, globalization, and the availability of or access or lack of access to resources. Consider this. In 1790, the population for Philadelphia was 28,000, 42,000 if you include the suburbs. The 2022 census estimates Philadelphia's population is now at over 1.5 million. Does that matter? Enough of my questions. It's time to turn the time over to the panel members who may have some of the answers. But before I do, I encourage you to stay engaged in civics. It matters, perhaps now more than ever. And if you're looking for ways to do that, attorneysforciviceducation.org. Thank you.
Thank you, Chief Judge Larillo. I will now introduce the members of our panel and kind of set the frame for our panel discussion that will take up the rest of our time. Our first panelist to my left is Professor Benji Cover. Professor Cover studied engineering, mathematics, and economics at the University of Toronto, international development at the London School of Economics, and law at Yale. Upon graduation, he worked on pretrial reform efforts at the Public Defender's Office in New Orleans as an Arthur Lyman Public Interest Fellow and Vital Projects Fund grant recipient. He then handled misdemeanor and felony cases in municipal and state court. In 2013, he became the legislative director for New Orleans City Council member LaToya Cantrell, focusing on policy issues including neighborhood revitalization, land use, economic development, immigration, health, education, criminal justice reform, and political reform. He has served as a visiting associate professor since 2014 and a tenure-track associate professor since 2017 at the University of Idaho College of Law, and he teaches constitutional law and election law. Professor Cover, do you have anything you'd like to say to our participants by way of introduction and why these topics are important to you?
Sure, thanks very much. Oh, do I have to go with this? Can you all hear me? Okay, thanks very much for that kind introduction. Good afternoon, it's an honor to be on this panel, and thank you to the organizers for making this event happen, and thank you to all of you for being here. So how do we interpret the U.S. Constitution, and specifically, how do we determine if the U.S. Constitution guarantees a particular individual right? Today we're going to be talking about different approaches to interpreting the Constitution, including originalism and textualism. So textualism is the idea that the words of the document itself matter. Originalism is the idea that the document should be interpreted in its historical context, considering the time when it was drafted and ratified. I think it's important to understand that there are different approaches to textualism. There are different approaches to originalism. There are disagreements between textualism and originalism. There are disagreements internal to textualism and internal to originalism. So there's different ways to do originalism. You could do original intended application. You could go back in time to the moment when the founders were drafting the text and ask, what did they think those words would mean in the future? How did they think those words would be understood? You could do original public meaning, focusing on how ordinary people at the time of the ratification would have understood the text. Originalists can argue with themselves. Textualists can argue with themselves. If they're really smart, an individual originalist can argue in their own head with themselves. With these different approaches to interpretation in mind, I want you to consider how the U.S. Supreme Court has interpreted the scope of individual rights under the U.S. Constitution. So the original Constitution, proposed in 1787, ratified in 1788, it contained very few provisions that protected individual rights. It was mostly a document about structure, setting up the federal constitution, separating powers into different branches, explaining the relationship between the federal government and the states, but it said very little about individual rights. And during the state ratifying conventions, a lot of people complained about that and argued that we need to have specific provisions in the Constitution that guarantee individual rights. And so eventually, in 1791, the Bill of Rights was added to the Constitution. and this is the first 10 amendments to the U.S. Constitution. This is what most people think of if you ask them, what are rights guaranteed by the Constitution? People talk about the First Amendment, freedom of speech, Second Amendment, right to bear arms. The Fifth Amendment takings clause says that the government can't take your property without just compensation, and the very important rights that criminal defendants enjoy under the Fourth, Fifth, Sixth, Eighth Amendments. The Bill of Rights, as interpreted by the U.S. Supreme Court, doesn't apply to the states. It only constrains the federal government. So there was a case in 1833 called Barron, where the U.S. Supreme Court said, according to the First Amendment, the United States can't establish a religion, but Idaho could if it wanted to. And the First Amendment does not prohibit Idaho from doing that. Because the first 10 amendments, the Bill of Rights, only constrains the federal government, does not constrain the states. So the next step in the way the U.S. Supreme Court interpreted individual rights is that slowly over time, they started to add additional constraints on the states. So after the Civil War, you get the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. They do a lot of really important things, but the 14th Amendment includes the Due Process Clause. And do we have the text of the Due Process Clause?
We do. Before we pivot to that, can I introduce our other two panelists really
sorry.
quickly? No, that's
Sorry.
okay. That's a great bit of information about the origin and why we're here today.
Sure.
I really appreciate that. Emily McMaster, a little further to my left, her introduction reads that since 1995, Emily has practiced employment, civil rights, and business litigation at California and Idaho law firms and as a deputy attorney general for the state of Idaho. She earned her JD at UCLA, the University of California at Los Angeles. In 2021, Emily launched McMaster Law, where she litigates employment, civil rights, and professional licensing disputes. She serves as a Title IX hearing officer and counsels employers on best practices. As a solo practitioner, Emily focuses on the legal space between personal rights and government regulation. Emily is admitted to the U.S. Supreme Court and the Ninth Circuit Court of Appeals, as well as the Idaho courts. In 2023, she was recognized as a Service Award recipient, and I would editorialize and say a well-deserved Service Award recipient. She chaired the employment section and labor law section and the government and public sector lawyers section of the Idaho State Bar, and has taught civil rights litigation at the University of Idaho College of Law. Emily is a member of the board of directors of Idaho Women Lawyers and a bencher in the Inns of Court and a member of the Idaho Trial Lawyers Association. And a little further to my left, David G. Robbins is an assistant U.S. attorney with the District of Idaho. Dave was born and raised in Colorado before joining the Air Force in 2003. He served in intelligence, where he received the Air Force Achievement Medal for his work related to nuclear weapons. And he mostly focuses on child cases. Did I get that right?
I work in Project Safe Childhood, which focuses on technologically facilitated sexual exploitation crimes. And for some reason, I'm here today to talk to you about the Second Amendment and guns. But yes.
Perfect. Now, pivoting back, Professor Cover, the 14th Amendment.
Okay, sorry I jumped the gun there. I'm an absent-minded law professor, and I just get worked up sometimes. But do you remember what I was saying? Okay. So before the Civil War, the Bill of Rights only applied to the federal government. After the Civil War, we get the Reconstruction Amendments, 13th, 14th, and 15th Amendments. They do a lot of very important things. But I want to focus on the Due Process Clause that says that no state can deprive any person of life, liberty, or property without due process of law. What started to happen is slowly over time, the U.S. Supreme Court started to decide that provisions of the Bill of Rights now apply to the states because they're embodied in the understanding of the Due Process Clause, right? So the United States can't establish a national religion, and Idaho can't establish a state religion. The United States has to respect freedom of speech, and Idaho has to too, because it's implicit in the concept of due process. Now, note that some of the rights in the Bill of Rights are kind of procedural rights, right? So you have the right to a lawyer in a criminal case. You have that right under the Sixth Amendment in a federal prosecution. You have that right under the 14th Amendment Due Process Clause in a state prosecution, because due process includes the right to counsel. But a bunch of the rights in the Bill of Rights are not procedural rights. They're substantive rights. They're not rights that say if the government wants to mess with you, they have to follow certain procedures. They're rights that say the government can't mess with you at all, right? So what started to happen is that the United States Supreme Court started to use the Due Process Clause to start to say that there are certain rights, not just procedural rights, but fundamental substantive rights that limits the ability of the government to interfere with people's liberties. Okay. If that's true, what are the things that the state can't mess with? What are people's individual rights? You know, the easy answer is to go through the Bill of Rights and to say those now apply equally to the federal government and the states. And the Supreme Court has mostly done that, except for a very small number of limited exceptions. So freedom of speech, right to bear arms, we enjoy those rights. They protect us against both the federal and state government. But what about extra-textual rights, unenumerated rights, rights that are not listed in the Bill of Rights or elsewhere in the Constitution? Can there be a right that is not on paper in the Constitution, but still fundamental and protected by the Due Process Clause? If you are a strict textualist, your first instinct might be no. The Constitution says what it means what it says, and if it doesn't say it, then it doesn't mean it. And if there's not a written right in the text, then that's not a real constitutional right. But I want to direct your attention to the Ninth Amendment. People know the Ninth Amendment? People talk about the First Amendment, freedom of speech, Second Amendment, right to bear arms. This is the Ninth Amendment. It's bonkers, okay? Because it says the enumeration in the Constitution of certain rights, listing rights in the Constitution, shall not be construed to deny or disparage others retained by the people. So just because we don't list a right in the Constitution doesn't mean it doesn't exist. This should make a textualist's head explode, right? Because if you really take textualism seriously, you need to follow the explicit text of the Ninth Amendment. And the explicit text of the Ninth Amendment says there are rights out there that are not explicitly in the text. Make sense? Okay. So then how do we identify these rights? You know, the U.S. Supreme Court has recognized unenumerated rights, rights that are not specifically listed in the Constitution. The right to interracial marriage in Loving versus Virginia, the right to same-sex marriage in the Obergefell case, the right to birth control, the right to have children, the right to direct your child's education and upbringing, to reside with relatives, the right to not undergo involuntary surgery, forced administration of drugs, or similar procedures. The court had recognized a right to abortion in Roe versus Wade and reaffirmed that right in Casey, but then it reversed that decision last term in Dobbs. What is the legal test the court uses to decide if an unenumerated right is a fundamental right protected by the Constitution? In a case called Washington versus Glucksberg in 1997, the court said there's a two-part test. First, when we describe the asserted right, we have to be really specific. We have to carefully define the right at a relatively high level of specificity. So you can't just say, you know, Glucksberg was about euthanasia. But the court said you can't just say the right to die with dignity. You have to say, I'm claiming the right to physician-assisted suicide. And that's the right that I'm claiming is fundamental. And then after you've specifically defined the right, you need to ask, as Judge Lorella was saying, if that right objectively is deeply rooted in the nation's history and tradition, implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if they were sacrificed. In Glucksberg, the court specifically defined the right as physician-assisted suicide and said that that right is not deeply rooted in the nation's history and tradition. However, it's not clear that the Glucksberg test captures all of these fundamental rights cases. You know, if the right in Loving versus Virginia was narrowly defined as the right of interracial marriage, it's not clear that that right was deeply rooted in the nation's history and tradition. Same goes for the right of same-sex marriage in the Obergefell case. Same goes for other rights like the right to birth control. 5 years after Glucksberg, the court decided Lawrence versus Texas and decided that adults enjoy a fundamental liberty interest protected by the 14th Amendment Due Process Clause to engage in intimate sexual conduct that is consensual, private, and non-commercial. It's not clear that the court was using the Glucksberg test in that case. It's not clear that the right in Lawrence versus Texas would have passed the Glucksberg test because it's not clear that that right, very specifically defined, is deeply rooted in the nation's history and tradition. It's in this context that the Dobbs decision I think this context helps explain why the Dobbs decision was so significant. The court concluded there's no fundamental right to abortion. Essentially, the court kind of reinvigorated the Glucksberg test and applied it very aggressively, concluded that the right to abortion is not deeply rooted in the nation's history and tradition. And the Dobbs majority thought that that was so obviously true that it had to overturn 5 decades of precedent since Roe versus Wade was decided in 1973. And so many wonder what that might mean for other unenumerated rights the court has previously recognized as fundamental, but that might not meet that definition of being deeply rooted in the nation's history and traditions.
Thank you, Professor Cover. I think that really sets the frame for our discussion and why we wanted to talk about this applicable test. And I think it really captures the subtitle of our program today is how do we balance these competing interests? I think to go hand in hand with what you've shared and with what Judge Lorello shared is it's interesting to note that since before our Constitution was signed and fully ratified, this debate on conflicting views on how to best interpret the Constitution, they really have existed since that day. There was not unanimity, and it's just honest to say that there wasn't. In fact, one of the core reasons that our Constitution does come with a Bill of Rights, that it was added to the Constitution, and the Bill of Rights is the first 10 amendments to our Constitution, is to help provide guidance on this question, the question of where do individual liberties arise from. One of the things I wanted to be very clear about as we launch into a more substantive discussion and allow our panel to share the rest of their expertise with us is that they're not necessarily sharing their personal or political opinions. I want to highlight this today because almost all of the cases we will discuss today have political overtones, or they can have sensitive topics. But the point of our panel today is to discuss these difficult and sensitive cases in a way that simply allows us to talk about the rights as the Supreme Court has announced them, not to take any particular position. One of the things I wanted to note, since we're here today in the Lincoln Auditorium, is that I think there is one lesson we can relearn from history about civility and about discussing difficult topics with civility. Abraham Lincoln, who obviously was our president, was noted at the time for working directly with his former political rivals. In fact, years ago, historian Doris Kearns Goodwin wrote a book called Team of Rivals that highlights this exact particular part of Lincoln's genius. He once said, in response to why did you do this, why did you invite your former political rivals to be in your cabinet, he said, I had looked the party over and concluded that these were the very strongest individuals. Then I had no right to deprive the country of their service. And so I think it's with that spirit that we want to start this discussion. And I love Judge Lorello's comments about the role of the judiciary in determining individual rights. If you've never heard of the case before, there's a famous case, 1803, Marbury versus Madison, that says it is the province of the judiciary to say what the law is. And that helps decide how we read the Constitution. So with the stage set for the discussion of the 14th Amendment and the Due Process Clause, as well as the 9th Amendment, I will ask each of the panelists in turn, and I'll start with Emily. Emily, do you have any justices or any decision in particular you want to highlight? I'm sorry, you asked me to skip this question for you. And I just remembered mid-asking it. David.
Yes. Yes, sir. Hello.
Do you have any justices, or especially for our students who are joining us today, do you have any justices or any particular decision that you want to highlight as a way of interpreting the Constitution that you has been helpful to you in your practice or that you want to share?
Well, that's kind of a difficult question, because when you say helpful to a prosecutor, my fundamental goal is to see that justice is secured and delivered, to protect constitutional rights, to represent the people, but to also make sure that the rights of the defendant are fully protected in a prosecution. So I don't really say helpful. If the Supreme Court comes down and says, here's Miranda, it's the law, well, that helps us, and that's the law, and we follow it, and we go accordingly. So I have struggled a little bit with that, and I'm sorry, my friend, only in the sense that to a prosecutor, my right is to see that what justice is done, and sometimes the concepts of justice evolve and shift with our nature and history and precedent. So having said that, I don't know if anything's particularly helpful, but I try to follow the law as best I can in my role.
Thank you. Professor Cover, do you have one particular, aside from the cases you've already discussed, that you feel like highlights or that you'd want to highlight for the students?
Just one example that I think is a good example where the court has not interpreted rights based on historical practices at the founding is with the Eighth Amendment ban on cruel and unusual punishment. There's been a lot of situations where the court has said it is cruel and unusual to administer the death penalty in a certain way or in a certain context, even though there's a lot of historical evidence that that was done at the founding. And so I think that, in the Eighth Amendment context, it might be the place where the court has been most explicit about embracing what they call evolving standards of decency and not being limited by historical tradition.
Perfect. One of the cases that you mentioned, Professor Cover, is Dobbs. And so I'm going to turn some time over to Emily to describe how the concepts we've been discussing, ordered liberty, history, the importance of historical context, how that relates to the Supreme Court's decision last year in Dobbs.
Thank you, Colby. All right. We were talking as you were coming in and sitting down and saying, wow, what a diverse crowd we have, because we have people that are early in their education and then lots of people here with old gray hair. So it's really a wide, diverse crowd. And because of that, I'm going to focus more on our younger participants today, because you're coming up next. And I have a few tidbits for some of us who've been practicing for many years as well. But the first thing I want to ask you out there is, if you are a woman of reproductive age, meaning that you think that you could get pregnant, raise your hand. Okay. And if you are somebody a young male or a person who thinks that you could get one of these young women pregnant, raise your hand. Okay. Okay, so let's ground this discussion. What we're going to talk about here applies to you. Like, this is your world. This is what you're coming up into. And so I hope that you will think about maybe coming into the law and becoming a lawyer and pursuing justice and looking at these issues and trying to decide them and argue them the way that you think is the right way to do. And if you're old and have gray hair, raise your hand, please. Okay, and if you're young, you need to go talk to one of these people. Like, especially some of the folks sitting, oh gosh, all over in the audience. I'm serious. Like, walk up to them afterwards and say, hey, Emily said I should come talk to you. Are you a lawyer? Or are you a judge? And they'll probably say yes, and then you can just launch in. So with that, grounding it, and we're going to have the same conversation, right, with the Second Amendment in a little while about the right to bear arms. So what we're talking about today is the Dobbs decision, but we do need to understand the history of how this has evolved. So many of you probably had grandparents that were alive in 1971. And in 1971, Roe v. Wade was decided by the United States Supreme Court. And in that decision, the United States Supreme Court said that there is a constitutional right of women to be able to control their bodies, and that means the right at certain points in a pregnancy to choose an abortion. And the court at that time, the United States Supreme Court, set up the test in trimesters, meaning there's 9 months of pregnancy. So the first 3 months, the second trimester after that, and then the final trimester. And the court said at that time, 1971, in that first trimester, the decision to get an abortion or not is between a woman and her doctor, and a state cannot interfere. But then after the fetus or the unborn becomes viable, like able to potentially live outside of that woman's body, the state can start to regulate abortion at that time. And that was the law for decades until 1992, and then there was a second case that came along. And that case was Planned Parenthood versus Casey. And in Planned Parenthood versus Casey, the United States Supreme Court affirmed that the right to an abortion, the right to choose what happens to your body, is a right under the Substantive Due Process Clause implied in the 14th Amendment, and that was a constitutional right. And they affirmed that, and they said that prior to viability, that woman and her doctor, they have the ability to control and make those decisions. And the court changed the test, kind of went away from the trimester test, and in Casey, the court started using an undue burden test and said that at that point, the state can regulate, but it can't impose an undue burden that gets into the path of the woman from choosing an abortion. So
Emily, can I pause you and ask a follow-up question, particularly because we have so many of our younger students here? When you talk about a test, is it fair to say that you're talking about the way the court evaluates the question in front of it? Is that right?
Yes.
Okay, perfect.
Yes. So the court can't just arbitrarily say, yes, you can get an abortion, or no, you can't get an abortion. The court formed a test. And under Roe, the test was this trimester test. And in 1992, under Casey, the court modified that test and said, well, we're going to look at it through the lens of, are you imposing an undue burden upon that pregnant person? And that was the test they used. And I'm glad you raised that, because then fast forward to the Dobbs case, which was just decided in June of last year, 2022. And the issue of, you can frame it as abortion or the right to choose, or there's different ways people will word that, came before the United States Supreme Court again. And at this time, there are 9 justices, right, on the United States Supreme Court, and there had been a number of new justices named to the court. And so the issue came before the court. It came up in a number of cases to the United States Supreme Court, but the court took it up on a Mississippi statute. And that statute before the court was whether the state of Mississippi could regulate abortion and prohibit abortions after 15 weeks. When 15 weeks is not quite the age that was understood to potentially be viability, I believe, at that time. Usually that might be later on in the pregnancy, right? We're starting to get into, further on in that second trimester. But so the Mississippi had said, well, we're going to prohibit abortions at 15 weeks, except in very narrow cases of medical emergency or in the case of a severe fetal abnormality. So that was what was before the United States Supreme Court. And the United States Supreme Court case in Dobbs overruled Casey and overruled Roe v. Wade and changed the direction of how we look at reproductive health and abortion. And in the Dobbs case, the court said there is no constitutional right to have an abortion. That's not a constitutional right. It's not a substantive due process right implied in the 14th Amendment of the Constitution. So for those of you in the room who either can get pregnant or get other people pregnant, does that mean the state of Idaho can prohibit you getting an abortion in Idaho now? Raise your hand if the answer is yes. Okay? And so, but other states, you can have an abortion. So the court modified and said, we're going to bump it back to the states. The states can regulate this area. It's a lot to handle, right? There's a lot of mouthful there. But let's go back to what Professor Kuffer was discussing, which is, what is the right at issue in Dobbs? The framing of the right is very, very important. And in Washington versus Glucksberg, the court said, right, that it has to be framed at a relatively high level of specificity. And so in Roe v. Wade, the right was framed by the Supreme Court as a personal sphere of privacy, a right to privacy in which you can do what you want with contraception, do what you want if you're a consenting adult with as far as sex, do what you want as far as raising your children safely and controlling their education, marry who you want to marry, including if they're of a different race or now of the same gender, that gender doesn't come into that. And so the court in 1971 and again in 1992 in Casey said the right to choose an abortion falls within that personal sphere of your right to control your body. And so we are going to uphold that as a constitutional right. Fast forward to Dobbs in 2022, and now the United States Supreme Court has said, we are going to frame the right as the right to get an abortion. And that is not recognized in our historical concepts of ordered liberty. That is not a right that was recognized back in 1868 when the 14th Amendment was adopted. And so because it was not a right back then, it was not recognized. In fact, it was criminalized back in the late 1800s. We are going to hold that there is no constitutional right to an abortion. So that framing of the right is very important. I wanted to talk for a minute about both intent and kind of how this plays out, because there's some interesting points in Dobbs. And one is that, as Professor Cover talked about, when you're looking at historical concepts of ordered liberty, are you looking at the original intent of the framers? So are you looking at what the people who ratified the 14th Amendment were thinking about at that time in 1868? Or are you looking at the original public meaning of what abortion meant back in 1868 and how it was treated in the public? And I think that the Dobbs majority came down and focused more on the public meaning. They looked at criminal statutes that criminalized abortion back in the late 1800s, and they said, because that's what went on at that time, you can't think that the framers or the ratifiers of the 14th Amendment thought abortion was okay. So they looked at it in terms of the public statutes. And I think there's one point I want to raise and kind of ask the panel to comment on maybe later in their presentations. But this sort of slippery slope issue that Professor Cover was raising earlier, which is, okay, well, you say that there's no implied right to an abortion because it's not expressly mentioned in the 14th Amendment. Well, what about the right to marry someone of a different race? And that's a case called Loving versus Virginia that came out much, much later in the 60s, I believe, correct? And so what about that? There's no right in the Constitution to marry someone of a different race, so does that go away as well? There's no express right in the Constitution to marry somebody who is your same sex, so does that go away as well? There's no right to birth control spelled out in the 14th Amendment of the United States Constitution. So, does that right go away as well? I'm going to let you weigh in on, there's other rights too. So there's this question about, okay, if you're saying that this historical concepts of ordered liberty is how we now need to define substantive due process rights under the 14th Amendment, does that mean all of these other rights go away as well? And the majority opinion said, no, they don't go away. And the reason is because those other rights do not involve the critical moral question posed by abortion. None of those other cases involve the destruction of potential life. So I'm struggling with that as an attorney because you've just told me what I need to do is look at what the world was like in 1868 and look at the statutes on the book and look what was going on in society. And that's where I need to look. You haven't told me to make any, if you're a judge, judicial activist decision about what's moral or what's immoral. You haven't told me to do that. You've said, look at the original meaning. But now in this majority opinion, they're saying, well, we understand that argument, but abortion's different because it presents a different moral question. And so that, I think, is a very important question. And if I can touch on, just for a moment, the dissent. So when you have 9 justices, right, they don't all agree. Does everybody in your family agree all the time what you want for dinner? No, they don't. Well, the 9 justices also don't agree about everything. And so you'll have a majority opinion. You might have people concurring in that majority opinion. Justice Thomas, for example, who I believe is in an interracial marriage, he mentions this issue of slippery slope, but he doesn't mention Loving versus Virginia, and I found that very interesting as well. And then we have the dissent, and the dissent was written by Justice Kagan, and she says a couple of things. She says, central to the decision in Casey was a full-throated statement of a woman's right to choose, and that the viability line was the line for balance between the state's interests and the woman's interests. So what she's saying is, we're not going to, as a dissenter, I think the test should not be this very structured historical concepts of ordered liberty looking back to 1868. She's saying, I want there to be some balance between the state's interests and the woman's interests, and that needs to be flexible under Casey. And she also says, at ratification of the 14th Amendment in 1868, the ratifiers did not understand women as full members in the community of we the people. She says that just 5 years after the 14th Amendment's ratification, the United States Supreme Court approved a state's decision to deny a license to practice law for a woman and suggested that the woman had no legal status apart from her husband. and that was citing a case of Bradwell versus State. So she says later in her opinion, in her dissent, that a woman had no legal existence separate from her husband. Justice Kagan in the dissent also says that the right should be framed as the right of every person to control their own body, and that the equal rights of women are inextricably, thank you, linked to the ability of women to control their reproductive rights. And that's where I stick. I think that's also an important phrase in the case. Equal rights are linked to the ability of women to make their own decisions about their reproductive rights and health. That is what the dissent says. So with that, I think I would turn it back to you, Colby.
Perfect. Thank you so much, Emily, for your perspective. Professor Cover, before I ask you to kind of address one of the questions that Emily raised, which I think is good for discussion, one of the things I think might be helpful is to help students understand the role that precedent plays at the Supreme Court level, and in particular, whether there's a test applicable to overturning precedent and how we saw those things at issue in Dobbs to kind of build that out a little bit so that they can have that understanding of how the system works. Would you mind addressing that?
Sure. So there's a fancy Latin term called stare decisis. And the idea behind it is that it's really important when a court makes a decision for that decision to stick and to be the law of the land. That leads to predictability. That leads to the uniformity of the law. It also makes us think that see the law as something that persists over time and doesn't change every time the composition of the court changes, right? Imagine if every time there's a new justice on the Supreme Court, every case can be relitigated, every case can be overturned, and we have a brand new set of legal rules and rights. For that reason, the court has said that it's usually going to respect its prior precedents and it's not going to overturn them. But note that I said usually, because the court has said that sometimes it will overturn prior precedents. And I think that most people would agree that we sometimes want the court to overturn prior precedent, right? So the famous case of Brown versus Board of Education that said we need to desegregate public schools overturned a prior case called Plessy versus Ferguson, which said it's okay to have separate but equal doctrine of racially segregated public schools, right? I think most people think it's a good thing that the Supreme Court overruled Plessy versus Ferguson in Brown versus Board of Education, but they also don't want every newly composed court to reconsider every new case. And so there's special factors that a court considers about whether it makes sense to overrule a particular precedent. It considers, not just was the precedent wrong, but how wrong was the precedent. It also considers, has it led to a situation there's no longer a workable test for the courts? And it also asks the question, have people been relying on this precedent? Have people organized their life, made decisions based on this precedent? One of the things that's really interesting about Roe versus Wade and Dobbs is that Roe versus Wade was decided in the 70s, and then people asked the court to overrule Roe versus Wade in the 90s, in the case that Emily was discussing, Casey versus Planned Parenthood. And the court explicitly considered those factors. Should we overrule this case? And they decided, no, we should not overrule the case. And part of why we shouldn't overrule the case is that people have been relying on Roe versus Wade. And it has proved to be workable. And then in Dobbs, the court considered again whether to overrule Roe versus Wade. But it was the second time that the court was considering whether to overrule Roe versus Wade. And so the court went through the same factors that it did in Casey, but it said this time we reach a different conclusion. We determined that Roe was so egregiously wrong when it was decided that it has to be overturned. And they also analyzed that reliance question very differently. And they said that we don't think there's been a lot of reliance on Roe versus Wade. The dissent disagreed with that very strongly. But they didn't think there was sufficient reliance interests, and so they overturned it. So Dobbs is a really important case about fundamental rights, but it's also a really important case about when the Supreme Court can change its mind and overturn prior precedent.
And Colby, can I weigh in on one more thing with that? I'm glad you raised that because, again, I'm talking to you if you're not a lawyer yet, because someday many of you will be lawyers, I hope. The reason this is important, stare decisis, and these tests that the court apply, is because you're from time to time going to see in the news a case that comes out and you think, well, why did the court decide that? I know that there were a lot of my friends who were thrilled with Dobbs because they felt that finally that prenatal, the interest in prenatal life was protected. And a lot of those friends had viewpoints that maybe were colored by family perspectives or religion or whatever, but they felt that finally the court had gotten it right. I had other people I knew who literally didn't get out of bed for a couple of days. Like literally, some of the top leading lawyers in this state did not get out of bed. They wouldn't answer their phone. I'm not joking about that. But I think at that time, I hadn't really understood that the reason for the court's decision was this historical concepts of order, liberty. And so that test, how a court decides something, is really, really important. It makes things understandable. At least you can understand why they reached one decision or the other, rather than just that they're willy-nilly making a decision, which they're not.
So to come back to really the way we framed this entire discussion, different ways to interpret the Constitution, is it fair to say that Dobbs was a strictly originalist interpretation on how to interpret the Constitution, or do any of the panelists want to speak to that? Where does it fall on the spectrum?
I'm going to answer a slightly different question, but do you want to answer whether it's an originalist opinion first?
I respect Emily enough to allow her to change my question.
Okay. I think most people would say, yes, it is, I think. But I told you, for those of you with gray hair, I was going to suggest a couple books. The first one I'm going to suggest, Professor John Ramel suggested this book to me. I don't know if I can say it if I do this, but it's called Worse Than Nothing, The Dangerous Fallacy of Originalism. It's by Erwin Chemerinsky, who I knew years ago when he was at USC. And in any event, he goes through this whole analysis of originalism and whether it's about the intent of the framer or the public meaning at the time. And he goes through several examples. And then what he does is he questions it. And he says, is originalism really originalism? Because he can point to several cases where originalists on the court will decide something differently. For example, in First Amendment religious cases. And so I highly recommend reading this book based upon, it's like an advertisement, isn't it? But based on where we are now with the court, I think it's a very important book to read. And I think that goes back to my question earlier about, well, if the test is the test of the public meaning back in 1868, then why does it matter that abortion might present a moral question that's different for purposes of applying the test? So originalism might not be originalism. I'll leave you with that.
Any thoughts on that, Professor Cover?
So I think that the majority decision was presenting their decision as an originalist decision. They were saying that the right way to decide if there's a right to abortion is to ask whether that right was deeply rooted in the nation's history and tradition. And then it did a historical analysis. So if you read the Dobbs case, there's like 20 pages of going through the history of abortion regulation from the colonial period, the time of the founding, and then focusing a lot on the time of the ratification of the 14th Amendment, which is in the 1860s. Some people have criticized the historical analysis and say that they interpreted things wrong or that they left out certain sources. I'm not enough of an expert on that to weigh in one way or the other. Other people, find it really hard to accept the originalist approach, specifically with respect to a right that only affects women in a way that's very different from the way that it affects men, looking at a historical period where women were not able to vote, right? So the 19th Amendment was ratified in 1920, which is about 50 years after the ratification of the 14th Amendment. So, the court asked the question, how much respect was there for a right to abortion during this historical period when women were not allowed to vote? They did not ask the question, and you could imagine this question, if men could get pregnant, or historically, if men were able to get pregnant, what would the degree of protection have been, right? Or if women participated fully in democratic life from the beginning, what would the degree of protection have been? But the court doesn't ask either of those counterfactual questions. It just asks the question, in that period of time before women had the right to vote, was abortion regulated and criminalized? And it concludes, yes, therefore there's no fundamental right to an abortion.
So I want to pivot now, I think with the stage set for how to understand originalism, how to understand the ordered liberty test, I want to pivot now to David. David, you have agreed to talk to us about the case of New York State Rifle and Pistol Association versus Bruin. And while this is a case that was also decided last term by the Supreme Court, I think just a few days after Dobbs, maybe the day after Dobbs, and while it does not, at least nominally, address the ordered liberty test, I'm wondering if you can help explain to us kind of the history behind how the courts have interpreted the Second Amendment and the role that history and historical context plays in that interpretation.
Certainly. Well, good afternoon, folks. My name is Dave Robbins. It's a pleasure to talk to you today. Now, at the very outset of this, I made a self-deprecating comment about how I don't know much about the Second Amendment. Well, I'll tell you what, being a criminal litigant, you never know what you have to be a conversant expert in from day to day. I have prosecuted everything from unlawfully taking geese out of season to capital murder. And I put a man, well, I didn't put a man on death row, but a man is on death row as a result of a prosecution I led. And part of that is you see all different types of litigation. And as a matter of fact, I had a case in which a person possessed a gun. That person was a convicted domestic batterer misdemeanant, meaning he had been previously convicted of domestic battery. Federal law prohibits possession of a firearm by that individual. It's a 922G9 crime. I prosecuted him, took him to trial. The jury returned a verdict of guilty. And up on appeal, and while we were pending sentencing, actually, this decision came down. So I was one of the first people in the country to actually litigate the effect of Bruin on the 922G9 provision. So I've been litigating before the Ninth Circuit. The Ninth Circuit heard our case, actually remanded it for further consideration in the district court. But to all those aspiring lawyers out there, just know that the legal profession is a very noble one. It's a very challenging one and a very dynamic one. Now, I've been tasked today with trying to give you a brief background about the Second Amendment and how the courts have interpreted the Second Amendment. Well, the Second Amendment is very simple. It's only 27 words. It was ratified in 1791, and it says that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Full stop. That's all it says. There's nothing more. There's no footnotes that help you know what it says. There's no ancillary texts that really provide a lot. So with those 27 words, we've been left to wonder an awful lot about what the scope of this amendment is. Now, the Second Amendment has gotten a lot of notoriety in the press, and rightfully so. At the very beginning, we talked about civility. And when I look at the Second Amendment and when I look at the court's interpretation of the Second Amendment, I'm very mindful of all the political debate that surrounds the Second Amendment. I am aware that gun control advocates have a different political philosophy typically than gun advocates or gun right advocates do. Gun control advocates tend to look at the Second Amendment and go, wow, that's old. It's obsolete. It's superannuated. It's no longer relevant. It's outmoded. This was written at a time when muskets were dominating. There was no AK-47 with 7.6239 and a 30-round clip. Why are we referencing this as if it is an inflexible rule? And then those who are gun rights advocates will take the opposite approach. They'll say that possession of a gun is a bulwark against tyranny. So if the state becomes oppressive or fails to provide self-defense, I can execute that myself, and that is my constitutionally given right. So the political philosophies, while very passionately held, are diametrically different. The other is the consequence of the interpretation. Now, a lot of people here, and I would challenge the young high school kids, it's easy to view these things as abstractions. I'm just here to get a grade in my class and a C, but know that the constitutional interpretation will impact your life. And it's the same thing with the gun control debate to some extent. When you look at it politically, those who advocate for gun control want state legislatures and other legislative bodies to pass laws to control guns to help lessen the epidemic of gun violence. On the other side of the spectrum, gun rights advocates say, no, I want my gun to be able to provide for my own self-defense, defense of my family, defense of others, defense of my home, defense of my property. So they both have goals in security, they just have opposite approaches to it. So here we are interpreting the Second Amendment while our citizenry really is swept up in the emotional cross-currents of the gun control debate. So it is important, though, and it's an important public issue that we currently face. So, back to interpreting it, though, absent all the politics. The first question with the Second Amendment is, what is the scope? Now, I told you what the Second Amendment actually says. It references the militia, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Originally, what that meant was very uncertain until about 2008. Originally, that could have meant you only had a gun if you were in service to a militia, and the individual right to carry firearms did not exist and was not enshrined in the Constitution. An alternative interpretation to that is no. This is an introductory clause, this is an operative clause, and you do have a right to carry a firearm under the Second Amendment. So there was a scope issue up until 2008 on what the Second Amendment actually meant. Now let's take that a step further. Let's assume that you do have an individual right to carry a firearm, and spoiler alert, you do, according to the Supreme Court. How far does that right go? Can I take that firearm into a school? Does my firearm rights extend to cannons and howitzers or a tank? What if I'm mentally ill, or what if I'm a child? So not only is there an individual right, but what is the scope of the individual right should you be granted one? And so the courts recently have been tasked, and they have issued opinions that define those relative scopes and rights. So I'd like to kind of segue into talking about the landmark decision, which is DC versus Heller. Now, the Heller decision is the precursor to the Bruin decision, which I will get to, but that is a very important case. Now, some background on the DC versus Heller case is that the District of Columbia had passed effectively a law, and please keep in mind I'm paraphrasing. I'm paraphrasing, and it's also Friday. I'm firing on 1/4 of a brain cell, because if you do become a lawyer, you will become a burnt-out shell of a litigator come Friday, and your memory will fail you. But just suffice it to say that in the District of Columbia around 2008, they had a law that effectively banned the possession of a handgun. And you could have a long arm, including a shotgun and a rifle, but it had to be disassembled or kept in a locked fashion in your home. Now, to all the young folks in my room, I challenge you, if you had a PlayStation 5 and if you had it at home and it had to be disassembled or locked away, do you really have a PlayStation 5? No, you can't play your video games. So the argument is because of that law, you couldn't really effectively use your firearms. So 6 individuals sued for relief in the district court of the District of Columbia, and the lawsuit was dismissed. It went up on appeal in the appellate court, and a 2-1 decision said, you know what, you do have an individual right to possess a firearm. The Supreme Court granted cert, and in a 5-4 opinion authored by Antonin Scalia, they held that, in fact, you do have an individual right to possess a firearm unconnected to service and militia for traditional lawful purposes, which include self-defense in your home. That's a mouthful, but that was the holding in the decision of Heller. Now, more to the point of this presentation is, how did the Supreme Court actually arrive and justify that conclusion? Well, they relied on largely 6 areas by my reading. The first thing they relied upon was a strict textual reading of the Second Amendment. I've already read to you and spoken to you the Second Amendment, but they divided it into 2 parts. They had what was called the prefatory section, which referenced the militia, and the operative section, which referenced the right. They said that that introductory commentary about the militia neither expanded or contracted nor impacted the operative part in the second portion. So while it's a wishful introduction, it did not constrain the second operative right, and therefore, pursuant to a plain textual reading of the Constitution, there is an individual right to have a firearm. They then went on, after reading the text strictly, to then look to the history surrounding the amendment. But before I get back to the history surrounding the amendment, I would like to help our high schoolers understand this decision a little bit more. I mentioned the word prefatory. That means introduction. And by the way, a lot about law is just trying to learn the vernacular. Most law you actually probably learn from your parents or guardians, in that a deal's a deal and it's your own dumb fault. That's about 50% of the law. Now, for an example on a textual reading, let's say grandma leaves you some money in her will, and grandma says, oh, you know what? I really want you to go to school. Don't play PlayStation. That will rot your mind. I hereby give you $5,000. Did grandma make contingent on you receiving that $5,000, meaning that you go to school and spend it there, or that you don't play PlayStation? It sounds a little bit more what's called precatory or wishful as an introduction, and the court kind of interpreted the Second Amendment along those lines. So that's how the text went in there, and I hope that was an understandable example of how the Supreme Court looked at that particular provision. The next thing they did is they got, well, I'm going to say nerdy. I mean, they got really deep into the history of the Second Amendment, and they realized that at the time the Second Amendment was passed, there was a big debate. And this goes back to the originalism that we've been talking about. There were the Federalists and the Anti-Federalists. The Federalists thought, oh my gosh, the Articles of Confederation, what a disaster that was. We need more central power in our federal government, or else this just ain't going to work. And then the Anti-Federalists were like, whoa, 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 that's pretty dangerous. I don't want you all up here in Washington, D.C. telling me what to do down here in Florida. I think we need individual and state rights. Back off with your central government power stuff. And so part of what was considered a compromise, at least to some historians, was the Second Amendment. It stripped the federal government from the ability to essentially say you can't have a militia, you can't have an individual right to possess a firearm, so therefore the central government could have a militia of its choice or a freestanding army to impose tyranny amongst all the ratifiers of the Bill of Rights and the Constitution. So some of the history surrounding that, at least supported the Supreme Court, according to the Supreme Court, supported that interpretation. The third thing they did is they looked at some other history surrounding the interpretation. Namely, they looked at a few state constitutions passed at the time that did reference an individual right to possess a firearm, both precedent to the passage, the ratification of the Bill of Rights, and subsequent thereto. And they pointed to that and said, look, this was understood by the common folks and understood by the legislatures to confer an individual right of a firearm. The next thing they did, and they did say this was of dubious analytical worth, was to say that some of the proposed Second Amendment versions that didn't quite make it off the cutting floor was that there was an individual right. They then next relied on some scholars who were contemporaneous to the ratification of the Bill of Rights and pointed out that their scholarly works did reflect an understanding of an individual right. And then sixth and last, the Supreme Court looks back at their own decisions. And Professor Cover covered it very admirably in that he said stare decisis. The Supreme Court looked to its decisions of previous Second Amendment law, and I meant it when I said they hadn't discovered or discussed the scope of the Second Amendment. They did have some decisions touching on the Second Amendment. They had Presser versus Illinois, Crookshanks, which is an interesting decision. I think that's the name of Hermione Granger's cat in the Harry Potter books. Then they had United States versus Miller in 1939, and another one, United States versus Schwimmer in 1929. And those cases tangentially discussed the Second Amendment, but they looked back at that and said none of those cases we previously decide constrain our subsequent analysis. So with those six foundations, they said you have an individual right to possess a firearm. And then in the second part of the decision, they went on to say, listen, we tell you, you have an individual right to possess a firearm, but like so many constitutional rights, it's not unlimited. You just can't take AK-47 Schwarzenegger style into a school, into a courthouse. You can't give them to the mentally insane. You're not entitled to your M1 Abrams tank. There are reasonable limitations on the exercise of the right. There are reasonable limitations on who can possess it, whether it be felons, mentally ill, or children, where they can possess it in the sensitive spaces, and of course, the type of weapons under the Miller Doctrine, in terms of if they're unusually dangerous like a tank, you may not have constitutional rights to possess that. So that was the second part of the Heller decision. The third part of the decision, of course, actually applied that recognized right to the D.C. law at issue. So you'll learn this when you go to law school. You have the rules and the application. You'll hear acronyms like CREAC or IRAC, issue, rules, applications, conclusions. Opinions often follow the same formula, and in the Heller decision at the very end, they said applying the understanding of the individual right under any level of scrutiny, whether it be strict, intermediate, or rational basis, there is no way we can justify the D.C. law as being constitutional. So the Heller decision struck down that broad ban on handgun possession and the limitations on how you could store a firearm in your home. So we have now, in 2008, very recently, within all of our lifetimes, have finally defined the scope of the Second Amendment as to whether or not there's an individual right. And I'm very mindful of this as I go through it, and I would impart this wisdom to some of the younger members of the audience. When you look at divisive topics, there are two types of analyses you can do. And you can do this when you study culture, you study law. You have positive analysis and normative analysis. A positive analysis is simply how it is. A normative analysis is how it should be. As I'm up here reciting the law to you, I'm saying this is a positive analysis. This is how the law states. So as I'm telling you have an individual right, there are geniuses with more degrees than a thermometer who are very intelligent. You could say, no, I disagree. That's not accurately historical. Supreme Court got it wrong. I'm simply telling you the positive analysis of what the status of the law is in our country. So we have established an individual right to possess a firearm. Now, how far does that right truly go? How do we define the outer margins? Are they clean? Are they shifting? Are they subject to the legislature? How do we make that determination? Well, we have New York State Rifle and Pistol Association versus Bruin 2022. It came out in June of last year, and I know the case well because obviously it derailed one of my prosecutions famously. And all of a sudden, I wouldn't say little, I'm a line assistant United States attorney, is now stuck smack dab on the cutting edge of the development of Second Amendment law. So now I'm having to talk to people much smarter than me in big buildings in Washington, D.C. about how to handle my case. But the Bruin decision provided some analysis and some framework going forward on how to define Second Amendment rights. Now, New York versus Bruin, at issue in that case was a law in which it was optional on whether or not a person could get a license to carry a firearm in a concealed basis in New York. Some folks got together and said, nope, I disagree with that. I believe their names are Koch and Nash. They sued, and once again, we're before the Supreme Court. And the issue before the Supreme Court kind of revolved around the specific issue of, do you have a right to carry a weapon in public for self-defense? However, it also turned on how do we actually know whether or not you have a right to carry a firearm in public for self-defense. And the Supreme Court said, yes, you do. You have a right to carry a firearm in public for self-defense subject to restrictions at law. And they didn't just say that you did. They went through a very exhausting analysis. And I'm trying to synopsize 60 pages here in about 2 minutes. But what they did is they started out by saying the circuit courts, you got it wrong. And you can really get into the weeds on what the circuit courts were doing. They were doing a means-ended test for the constitutionality of firearms. Suffice it to say, what they would ask is, did the regulation prohibit conduct that was within the Second Amendment? And if it did it strike at the core of the Second Amendment? And if it struck at the core of the Second Amendment, you're getting strict scrutiny. If it was just not related to the core, then you got intermediate scrutiny. So it could be depending on the scrutiny level, that determined the validity of the regulation. And I won't bore you with the details, but the Supreme Court came out emphatically and said, you got that wrong. We're not doing means-ended scrutiny. To the exercise of your constitutional right, courts are not empowered to look at that and determine, oh, you have an important enough reason to exercise that right. So the court started off by saying and analyzing how Heller was decided and saying, consistent with the original interpretation in the history of Heller, that the means-ended test is not consistent with the nation's historic tradition of regulating firearms, and said all the circuit courts had it wrong. Now, they did make some arguments and some statements affirmatively with that, and they compared it to other amendments, and they seem to make some degree of sense, right? If you want to speak politically, you don't have to go to a judge and say, hey, judge, I'd like to speak politically, and the judge goes, that's not important enough. You don't have a right. Or, oh, yes, it is important enough. You have a right. Same with the exercise of your possession of firearms for self-defense. They kind of analogized the possession to the speech and said, nowhere else in the Constitution do you have to get legislature's prior approval before exercising the right, so we're not going to do the means-ended test and scrutiny. So they stepped through it, though. And now what is the test that we use? Well, the test is up on the screen, and I direct your attention there. Just paraphrasing, the test is if the regulation and the conduct touches on, in the plain text of what would be a Second Amendment activity, it is presumptively unconstitutional. The analysis then shifts to the government or the proponent of the regulation to show that the regulation is consistent with the nation's historic firearm regulation. Now, what's interesting about this opinion, if you want to get really analytical as to the interpretive mechanisms, Justice Thomas wrote a defense of history. He wrote, listen, going to history is better than it is going to a judge's discretion in a means-ended test. He said, going to history is better because even though it's difficult, at least we know what we're aiming at, and judges are ill-equipped as non-subject matter experts to make empirical determinations about contemporary social issues where history is fixed as a guiding star and will navigate us to more certain results. I'm adding some colorful commentary, though, that wasn't actually in there, but that's what Justice Thomas effectively was trying to state in his opinion. So after he stated that this is the current test, he gave some breadcrumbs on how practitioners actually have to apply it. And we all have to agree that the circumstances now are far different than the circumstances at the time of the ratification of the amendment. So Justice Thomas fully admits, citing McCulloch versus Maryland, that the Constitution has to have flexibility in its interpretation, or else it just won't simply live. It has to be adaptable to the crises of the modern day. And to do that, regulation may pass constitutional muster, but only if there's a historical analog. So you can say, oh, you can't carry a firearm into a kindergarten, but you have to find something in history that was analogous to that situation to justify it. And there's a lot of commentary on how a court can do that, and how the analogies are to be received and how the analogies are to be evaluated. The analogies are not meant to be a regulatory straitjacket and they have to be perfect all the time, but they are also not a regulatory blank check in that you can have any sort of loose analogy and therefore justify it. Justice Thomas gives an opinion in the brief that was kind of illuminating. He said that, let's imagine you have a green truck and a green hat. Well, they're analogous to one another if the question is, what are green? Or if your metric for the analogy is what is green. If your metric for the analogy is what you can put on your head, they're not analogous, only the hat would be. So he's very cautious about instructing courts in the use of analogies and historical precedent to determine what is appropriate in those particular cases. Moving on, they actually applied this historical analogy test, and they did also expand the right. Part 3A of the opinion said, oh yeah, you have an individual right to carry a firearm in public for self-defense. And then Part 3B of the opinion said that all the historical precedents cited by it would have been New York and trying to maintain the legislation. They said those just simply didn't pass constitutional muster. The historical analogies were either too old, too remote, too specious, or didn't apply to enough of the population to actually compel a conclusion that New York's May license scheme for firearms was constitutional, and they struck down the opinion. So with that, that's where we currently are in the court, though. We don't know the outer extent of the Second Amendment at this point. We're currently working our way through, and I think the next 5 to 10 years of Supreme Court jurisprudence in the Second Amendment will be very illustrative as we try to figure out where the Second Amendment is actually headed. As I mentioned, my case involved a 922G9. Lawyers have rules of confidentiality. We're very hesitant to speak about our cases in public. We are watching circuits all over to see how courts are addressing the issues, but right now it's a largely unknown. And with that, I thank you for your attention, and I will pass it back to you, Colby.
Thank you for that. I was going to say that historical context, but you provided a lot more than that, and I really appreciate it. And I like your tips about what it's like to be an attorney, particularly on a Friday afternoon.
Truth.
One of the things that I think, as we move now into our discussion kind of between the relationship between these cases and between these notions of how to interpret the Constitution, one of the things I think might be a good way to start, and I'll kick this question to each of the panelists if they want to address it, is in Bruin, the court essentially recognizes the way that David has explained it to us, and the test as it's on the screen, I think well establishes that for that right, which is an explicit right provided in the Second Amendment, for the government to curtail that at all, there has to be a historical analog for a regulation that's going to curtail that right. That is kind of a reverse of the analysis we discussed with Dobbs and with the other, well, really with Dobbs and the substantive due process cases that led to Dobbs. And one of the reasons for that, and this is, I think, a good jumping off point for the panelists, is because we are talking about unenumerated rights. So I think that gives us a good way to start this discussion of why are those treated differently? Is that to move from the way that David put it, to move from positive analysis to normative analysis, is that the way that it should be, I think is the question. Or have I correctly stated that, Professor Cover? I think you can correct me if I'm wrong. Are those really foils of each other, or the opposite of each other?
Yeah, I mean, they're similar. In the case of the scope of the right for the Second Amendment, if you show that there's a history and tradition of protecting firearm regulation, then that establishes the scope of the right today. When it comes to unenumerated rights, like right to abortion, Because there were laws that prohibited and criminalized abortion historically, that shows that there is not a right to abortion today, according to the analysis of the Dobbs majority.
Right, and so I think it's important to highlight the difference, right? It's not just the Supreme Court picking and choosing on which topics it applies different tests. There are actual differences in that the Second Amendment is an explicit right versus rights that are not explicit. Is that correct?
Yeah. But I think they both reflect that the current U.S. Supreme Court majority in both of these cases is very interested in a historical approach to analysis.
Thank you. Emily, do you have any comments on that? Your light is on.
Yes, of course I do. I think it goes back again to who wrote the text back in 1868, and were there any women involved, or was it only men in regards to the rights in Dobbs? So I do understand the difference in if it's an express right in the Constitution, is there a state right to regulate that versus, well, what if it's an unenumerated right and we're sort of fighting a different battle there? Some would argue it puts women, 5 steps behind the start line. And I do want to point out to another book advertisement for our lawyers today. Another book that was recommended to me was Idaho Constitution by Dennis Colson, The Tie That Binds. And this is a historical analysis of the Idaho Constitution. And the one thing I wanted to point out here is I have gone back to the territorial laws and tried to read them. I have gone back to the Idaho Constitution and tried to read the record. If you haven't done that, it's a lot of fun, but it's really hard to understand because they speak a different language than our time. And one of the things I looked for in the Idaho constitutional record was the number of women that spoke up at the Constitutional Convention. And I think, I could be wrong on this, someone can correct me, but I think there were 2. And they were both speaking for women's right to vote, for women's suffrage. And one was Henrietta Skelton, and she was advocating it in connection with also prohibition, to put something into the Constitution that would regulate the use of alcohol. And so there was this tie between the temperance, women who wanted temperance and prohibition. And then there was another woman who I just really enjoyed. Her name was Abigail Scott Dunway, and she came and spoke, and she tried to separate those issues. And it took me I'm not as smart as my colleague David here, or my colleague Professor Cover here. Maybe I am. Maybe I'm smarter. But but as I was reading, it took me several pages before I realized that, the men in the room didn't want to give women the right to vote because they were afraid they were going to lose the drink. I mean, that was how basic that was for me, was, they didn't want to give women the right to vote. One of the reasons was because they didn't want to stop drinking. You put yourself back in that time in the Wild West in Idaho and where we were at that time. And also one other point on that would be just who was writing the history at that point? Were there women? I'm not a history professor, so I would like to be corrected on this, but how many women were writing the history of Idaho back in the late 1800s? And if they were they writing about women? Or was it really writing about romanticism in the Wild West and come to Idaho and boisterism to bring people to the state? And so when you're going back to look at that historical text, consider that as well.
Can I add one thing to that? So there's a case that the U.S. Supreme Court's going to consider this upcoming term, which asks the question, does the Second Amendment include the right to have a firearm in the context of domestic violence when there's a temporary restraining order issued against somebody? I think that it's not clear how the court's going to analyze this, because the court has said in Bruin that it's supposed to be a historical test, right? So you're supposed to ask the question, well, was that part of the traditional regulation of firearms historically, right? Historically, we didn't have temporary restraining orders in the context of domestic violence, right? So it's not clear how to frame the question and what the right historical analogy is. There's also, building off what Emily said, historically, the scope of the right to bear arms was decided at a time when women did not have full participation. And so it'll be interesting to see how the court addresses that question.
And of course, please know when we talk about constitutional interpretation, there's many different ways to look at the Constitution. It's like taking glasses on and putting glasses off. I would say that sometimes one may not be better than the other. Perhaps there's trade-offs. But if you would like a discussion, too, on criticisms of originalism and the history and the textual things, if you read the dissenting opinion in the Bruin decision, and it is just drafted by Justice Breyer and joined by Kagan and Sotomayor, it provides some commentaries that my colleagues have reflected on. When we look to history, whose history? Are we talking what period of history? Is it either ratification or Reconstructionist area? What if there's conflicting, ambiguous, or different history? Where do you put what's consonant with your vision? And also, courts are not historians. They're staffed by lawyers, especially a district court. It's very difficult to take a line attorney at a district attorney's office and say, in addition to your 120 felonies, now you have to go to the library, bury your nose in a book, and provide all the history regarding this in an analog to a court to make a determination. So I'm not saying these as my personal criticisms of the approach, but they are contained in the dissenting opinion of the Bruin decision.
Yeah, and I think just to close, one I would share, there's a pair of companion cases I like to talk about. I used to work property tax cases for the state, and there's a pair of cases decided by the Idaho Supreme Court, one in 1967, one in 1981, I think, where they are asked to decide about how to construe property tax exemptions. And one of the things that the court decides in the 1967 case, it's a case called Idaho Telephone Company versus Baird. They decide that if they go to historical context, they go to the proceedings and debates of the Idaho Constitution, they look at the text of the Constitution, and they decide, we have 5 justices on our Supreme Court, they decide 3-2 that if property is going to be exempt from property taxation in Idaho, that the founders' intent was that it be wholly exempt or not exempt at all. And in the 1981 case, a different makeup of the court, obviously, but the same court looks at the same language from the proceedings and debates, looks at the same language in the Constitution, and decides 3-2 that previous decision was wrong. And that's one of the tricks. I like the way David put it with looking at cases with different glasses on. I often describe originalism or different approaches to the Constitution as tools in a tool bag that can be pulled out. Because in that case, the 1981 case, the Supreme Court I don't want to say changed its mind, I don't think that's correct, but they looked at different parts of the history, even though they were looking collectively at the same question. And so that's one of the difficulties, I think, to keep in mind, both for our practitioners and for the students as they go forward and try and understand our system, is that this is an important part of the system in how to interpret the Constitution. I think just to close, since our time has elapsed, and I'm so glad that we've been able to have such a good, productive discussion on these questions. One of the last things I'd share with you, particularly for the students, is Carl Sagan, who was a scientist, science educator. He was responsible for the Cosmos series. He wrote a book in 1996, right before he passed, where and this is really my conclusion to say, why are we talking about these things? Why are we talking about civic education? Why are we talking about what the court does? This is one of the quotes that Carl Sagan gives in a book he wrote about, the last chapter was about civics and caring about civics. And Carl Sagan wrote this: if we can't think for ourselves, if we're unwilling to question authority, then we are just putty in the hands of those in power. But if the citizens are educated and they form their own opinions, then those in power work for us. In every country, we should be teaching our children the scientific method and the reasons for a Bill of Rights. With it comes a certain decency, humility, and community spirit. And so I think it's with that I'd invite you to go forth and either get back to your workday on a lovely Friday afternoon or to go back to class. And thank you so much for joining us as we've talked about the role that the Constitution plays in interpreting our individual rights. I thank you for being here, and please join me in thanking our panel for sharing their expertise with us.